If you're charged in state court with a felony crime, you usually have a right to a preliminary hearing. Now, a preliminary hearing is basically like a miniature version of a trial. Now, the difference is, instead of having a jury decide whether or not a crime happened, a judge decides. And usually it's just the judge there, and the prosecutor, the defense attorney, and the defendant. Now, the prosecutor will call a few witnesses and won't do the full-blown jury trial witness list. They'll just do a few witnesses for the preliminary hearing. Now, the whole point of the preliminary hearing is to make sure that there's enough evidence to move forward towards trial. Now, the nice thing about a preliminary hearing is it's a nice way for the defendant to be able to see what evidence they've got against them. Now, the standard of proof at a preliminary hearing is probable cause. So that's a much lower standard than beyond a reasonable doubt, which is the standard of proof at a jury trial. So the chances are the judge is probably going to find that there's probable cause at a preliminary hearing. But like I said, there's a lot of advantages to going forward with the preliminary hearing because you find out what the evidence in the case is going to look like. And sometimes during the cross-examination portion by the defense attorney, you can get witnesses to trip up and then use those statements against them when we get to jury trial time. So if you're facing a felony criminal charge in state court, you need to get an attorney to fight for your rights at the preliminary hearing.